So it's my pleasure to introduce Ian Snaith. Ian is known to many people in the co-op movement, both in the UK and internationally. Both an academic and a practitioner of cooperative law, has written a wide variety of publications, including the well-known handbook on cooperative law used by many co-op lawyers, including myself and others. I've relied on it extensively, but also written in a wide variety of other publications and been pivotal in representing the UK in international co-op law discussions. But also, as well as the public stuff which people see, I know Ian's also been hugely influential, often quietly behind the scenes, advising societies or advising the FCA on the registration function and other things like that. So has a huge influence on the field of cooperative law. So it's my pleasure to welcome Ian, who I'll invite to start us off.
Right, thank you very much, Ian. Very flattering, very kind of you. Now, basically, I think we'll address three key issues which Ian has raised, but I don't know how much people know about me. Very briefly, I was a lecturer at the University of Leicester for many years, from 1979 till I suppose it was 2010 or something. I retired, and I've still done odd bits since then. I'll talk a little bit about the co-op law book and so on when that's appropriate. But yeah, so basically an academic, a little bit of work as a practitioner. I mean, I did qualify as a solicitor, and I worked as a practitioner and retired from that only at the end of March this year, actually, for the Anthony Collins solicitors in Birmingham, who are do almost entirely cooperative and community benefit society work. So it was very interesting to work for them. So that's my history, very briefly. Geordie originally, but lived in the Midlands for many, many years, since 1965 to be precise. So I think that's enough about me. So I don't know if you want to ask questions, Ian, and is that next?
Yeah, so I think you've touched upon your career there and given a high level overview of the things you've done. I think, what piece of work would you say you're most proud of?
Right, well, thank you, Ian. I think I would have to say the book I published in 1984, which is an inordinately long time ago, really, isn't it? Which is called The Law of Cooperatives. Thanks for holding it up. The Law of Cooperatives. And I'll just say a little bit about how that came about, really. I mean, there were essentially three main reasons why I chose to write about cooperative law. I mean, first of all, I was a legal academic, and I was under some pressure from the university to write a book. And of course, the pressure is always to write something original, or at least that isn't already done. So this was my choice. Why did I choose cooperatives? Well, essentially, I would say there were three main reasons. The first one is, had a certain level of family connection. My grandfather, my mother's father, had actually worked for the Glasgow Cooperative Society. And you get an idea of when that was. He went off to the First World War, having been conscripted, and came back and got his job back at the local co-op. You know, he worked in the grocery bit. My mother, his daughter, also worked for the co-op up in Glasgow, ended up in the department store in Glasgow. So there was that kind of family history. And I do remember as a child, you know, we used to shop at the local co-op all the time. I have to say, until a point in the 1960s when, and I think this is a general trend that I've read about, it became the case that Tesco's prices were so much cheaper in the town where we lived than the co-op prices that waiting for the dividend didn't seem appropriate. So my mother moved over to shopping in Tesco's then, which is a sad thing, but also significant because I think that happened to quite a lot of people. So there's a bit of family history as one reason I was interested in cooperatives. The second one is that I was already working a little bit on company law as part of my work at the university. And essentially, I could see that in those days, certainly in the 80s, the early 80s, there were a lot of company law principles that were going to apply to cooperatives. I mean, one example was that in those days, company directors' duties, for example, were purely kind of common law and equity-based. They weren't codified in the way they now are in the Companies Act 2006. And therefore, it was fairly easy to see that you could apply those to directors of cooperative societies, just as you apply them to directors of companies. So that was an example of the kind of thing you could do. And I could see that I could take a company law book, really, look at the main chapter headings and divisions and say, well, how do they apply to cooperatives? And that was, in a way, the basis for the Law of Cooperatives book. So that was one of the reasons. The third reason, really, was that it was evident once I started looking at it, there weren't any books on cooperative law. I mean, there were valid and noble attempts by people, but not really by lawyers. And they didn't have the kind of granular legal referencing, to particular sections, cases, and legal sources that you would expect in a legal text. So that was another reason I could do that, and that would make a book that would be sort of reputable, but also of interest to me to do it. The one place where there were references actually was in Holsbury's Laws. I don't suppose anyone uses that now, but it was the old encyclopedic law book in many, many volumes. And if you went to the volume on, of course, industrial and provident societies, which is what they were then called, a man called Keith Brading was the editor of that. And he was the registrar of friendly societies at that time in the early 80s. And he had written excellent sort of legal, fully referenced legal stuff there. And obviously I did draw on that a bit while giving credit and referencing it. And in fact, then later on, I got to meet Keith, who at an age not dissimilar to the one I'm at now, in his 70s, still driving around a sports car, and a great character who allegedly had worked in MI6 during the war, but there we are. So that's a slight digression in the sense that he had done the work on having the references, in fairness. So that was the motivation for doing it. The current version is, of course, not the Law of Cooperatives, but rather the Handbook of Cooperative and Community Benefit Society Law. And in fairness, I should say, I edited that, and the contributions came from many different people, including, for instance, David Alcock, Anthony Collins, and a whole range of other people who wrote bits of it. So it was based on my text being updated and people working on it. So that was how I came to have the book out. So I'm happy to say more if people have other questions on what I regard as what I'm proudest of and of that book. So I'll pause here and ask if there's anything else people want to ask, or if there's anything in the chat.
I suppose one question that springs to mind while people are thinking on that is, what was the reception like to the book, and what was your interaction with practitioners in the movement after the publication of the book?
Thanks, that's a good question. Okay, well, shortly after I published it, I was contacted by Cooperatives UK as the Cooperative Union, as they then were, and they'd set up something called the Institute of Cooperative Directors, which was an attempt to kind of give more training to directors of cooperatives. And they recruited me to kind of take part in that and do a session on legal duties and so on, which I did for many years, wandering around, often at the late lamented Cooperative College over near Loughborough, Stamford Hall, but also elsewhere as requested or required. So that was a very interesting thing to do, and it gave me more information about what was going on the ground, and I actually enjoyed that enormously and found it very helpful. So there was that. Then as years passed, people at the Cooperative Union, asked me to do more things. So, a bit more research, a bit more advice and so on for them and for their member societies. So that was my initial involvement with the movement. In terms, as I mentioned, Keith Brading at this stage was the recently former Chief Registrar of Friendly Society, so I was in touch with him quite a lot. So yeah, that was, I suppose, the main involvement, really. So yeah.
Yeah.
Shall I?
As I say, and when obviously that set out really useful resources for people in the UK, and I suppose when probably an observation of the last probably 10 or 15 years, there's been more work internationally on trying to establish cooperative law as a field of law. And I know you've done work on things like the International Handbook of Co-op Law and that kind of thing. How did you go from writing on the UK context to the involvement in things like the principles of European co-op legislation and that kind of thing?
It came really from being, in a sense, the only person working in it here, because I got invited, I can't remember who did it, but there was a conference or a meeting organized in one of the Spanish cities, I don't remember which one, and I went to that, and that allowed me to meet a whole range of people from different European cooperative movements. So Hans Munkner, for instance, the famous German cooperative academic, and a range of people from Spain. It was in Bilbao, I've remembered. A range of people in Spain, France, other continental European systems. And of course, by meeting them and talking to them, you become interested in that. And then there was established a group called PCOL, the Principles of European Cooperative Law is what that stood for. And this was an attempt, which, to be honest, was a fairly standard continental European approach, to extract core principles about cooperative law across the whole of Europe. And so I participated in that. I was part of the group that worked on it. And that led to the International Handbook, which you mentioned, which is a collection of I think, helpful essays or pieces of information about cooperative law in a whole range of different jurisdictions, different countries. I always admired the fact that cooperation was much more established and clearly had legal status in continental countries. However, I actually am a great fan of our traditional approach in the UK, which is essentially that that rather than defining exactly what a cooperative is in a cooperative act, and then insisting, as most European systems do, that everybody who wants to be a cooperative must register under that act, like it or not. We have the system where if you want to set up a cooperative, of course you can use, and it's probably wise to use, the Cooperative and Community Benefits Societies Act 2014, as it now is. But if you want to use a partnership of any kind, most obviously limited liability partnership, you're free to do that. If you want to use a company of any kind, you are free to do that. But of course, those forms have to be tailored to cooperative use. If you just use an off-the-shelf company or LLP, you'll end up with something that isn't really suited for cooperatives. So, for example, to take the company example, that will give all the power to shareholders. So that's the opposite of what you want for a cooperative. Or the LLP, you know, has similar problems, that it makes assumptions that are not appropriate for cooperatives. But I do think it's important that people setting up cooperatives have the choice of using those other structures. And one example I would cite is that a lot of the recent tech-based worker cooperatives for programmers, developers, and so on are registered as companies or LLPs rather than as societies. So I'm in favor of choice for people, which helps the system to evolve and helps things to develop. But an absolutely essential qualification to that is the constitution of whatever you're using must be changed, and ideally the provisions entrenched and made either impossible to change or very hard to change, which make it a cooperative. And so essentially controlled by a stakeholder group other than investors. One member, one vote, well, the ICA principles that I'm sure you're all familiar with. One member, one vote, not one share, one vote. Open membership and voluntary membership, very important. Member economic participation, which is more often here honoured in the breach rather than the actual carrying of it out. But that means traditionally you get a percentage, what on the continent is called a patronage refund, to your use, for your use of the cooperative. Autonomy and independence, that was of course only introduced as a principle after the Soviet Union collapsed, because that certainly wasn't the case there, and they wanted to be able to say they had cooperatives. Education, training, information, really important, but again, it's probably best to leave societies to do that themselves. Cooperation among cooperatives, very important that it's facilitated, but don't think it should be compulsory. And then they've added concern for the community in addition, which again is valid and beneficial, but these things have to be treated with some caution. So I've probably gone on it rather to great length, excessive length about that. Apologies for that, but hopefully it was a bit useful.
That's quite all right, and that leads us nicely into perhaps the main theme, because looking at this call, we've got a range of people that have, I can see, that have spent a long time in the area of cooperative law, and other people that are much newer to it. So reflecting on your time in co-op law, what advice would you give to a lawyer about getting involved in cooperative law?
Okay, well, my thoughts on that. I mean, the first thing is that for cooperatives, more perhaps than companies or other structures, context and history are extremely important, because there is a tendency for even people who are quite experienced in dealing with cooperatives to think they're a kind of company. And the point is that they're not, and they shouldn't be seen that way. So the key element of that, which I've already mentioned and run through, is the International Cooperative Alliance identity statement about cooperatives, which is the list of traditional cooperative principles, which is a litmus test really for what a cooperative is. But that reflects context and history, and that it is fundamentally different from an investor-owned and controlled company, which is a different animal. Not saying they shouldn't exist, just they are very different. So what is the difference? Well, one way of seeing that is that in a cooperative, as opposed to an investor-controlled company, a different stakeholder group is in control. So in the classic investor-controlled company, the investors have control, and they have control because they have the votes. They can remove the board, replace the board, they can run the whole show, they can amend the constitution and so on. Whereas in a cooperative, those powers should be in the hands of a different group. Now, there's no fixed rule about which group. Common examples would be people who buy things from it, consumers, which is the big movement in the UK. Traditionally, historically, the major cooperative movement in the UK involves consumers being in control. But equally, it could be employees or workers. So you could say they are the members and they vote on everything and have power. But in other examples, for instance, in agriculture, it's common to have kind of marketing cooperatives where control is in the hands of probably small businesses, farms and farmers, who are selling things, and they are combining in a cooperative in order to have a better chance of getting a better deal from the large-scale merchants who buy up their produce. So that is an example of being controlled by suppliers, you know. So consumers, suppliers, employees are the main ones. And obviously in a true cooperative, housing cooperative, I was going to say, a true housing cooperative, it would be controlled by the tenants entirely. That is different from a housing association, which is not a cooperative. It is a community benefit society, different animal. So those are the reasons. That is the essence of what I see a cooperative as being, and that reflects the the ICA principles, which I do think are central. But one word on the ICA principles, maybe this fits better later on, is I'm against the ICA principles being in the legislation. Some people argue that the law should actually contain within it the full text of the ICA principles. Whereas our system, since the beginnings of cooperatives, and indeed before them friendly societies, has always been that there is a requirement that you must be a bona fide cooperative. That goes back a long way. But the question of whether that is the case or not is left to an administrative body. And currently, of course, that's the FCA, who I think do a perfectly good job on that, and who drafted guidance to help people to understand how they'd go about deciding that. But it's an administrative decision. And why do I think this is important? Well, I think one major problem is if you write all the detail into an Act of Parliament or even regulations, it's a slow, complicated process to change it. So if the ICA decides it's going to change, revise, add to the principles, if you've got them in legislation, you actually have to go through the whole parliamentary process to amend the legislation to change them. And even if it's regulations, you have to persuade a government department to go about changing them. They have to lie before Parliament and all that. So it's very slow and it's very cumbersome and it's a bit rigid. Whereas if you have the administrative process, which is historically what's always happened in the UK, that gives more flexibility, more fluidity, and I'm in favor of that. I actually don't think you should put the principles in legislation. And another feature of that is, of course, that in continental Europe, that is normally done. And you have a cooperative law. And in many cases, if not all, there may be others present who can correct me on this, but my understanding is that in many of those jurisdictions on the continent, if you want to set up a cooperative, you can only use the cooperative law. You can't set up a cooperative as a company or a partnership or anything else. Whereas here, you can set up whatever you like as a cooperative, although it will only be a true cooperative if you actually have the cooperative nature written in there. So the control is in a different stakeholder group and there's one member, one vote, not one share, one vote, and the rest of the things I've outlined. You have to have all those in there and ideally entrenched, which under Section 22 of the Current Companies Act you can do, saying those provisions can't be changed at all or can only be changed by a very large majority. So if you do all that, it's fine to use a company or I tried to find out whether you could entrench something in an LLP, and I failed. I couldn't figure out what the answer was. I suspect there isn't an entrenchment provision for an LLP. But the important thing is that it is a cooperative, and it can't be changed from being cooperative easily. I mean, at least it requires a big majority. So sorry, that was a bit of a ramble, but essentially, I'm in favor of using different structures as long as the structure is tailored to be a cooperative. And finally, you can only use the word cooperative in the name if you satisfy, for example, Companies House, if it's a company, who I suspect Ian would be able to tell us, actually immediately come to the FCA and say, well, is this really a cooperative? You have to satisfy Companies House that it really is a cooperative before you're allowed to use that name in the name of the company and so on. So those are my thoughts on that point, really, on structures and so on. And so time for me to shut up now and let other people say something.
That starts to take it on to the next area, but before we do, there's an interesting question in the chat which I'll reflect back to the meeting, and I think it's I don't know whether the individual wants to say it themselves, but I'm happy to say it if not. But I think the question is looking at, when you look at the co-op legislation across the world, there are statutes that say nothing about cooperative identity and allow different types of ownership and finance, and that can be in direct conflict with the principles. And that, you know, many statutes make no mention of the co-op identity. So I suppose it's a little bit around the interaction between, is something a co-op or not? Does statute ensure that? Or even if it thinks it does, is there still a risk that something isn't a cooperative? So perhaps something around the tension there between the statute making something a co-op or something using a co-op statute when it's not one, and whether there are any interesting thoughts or reflections on that.
Well, my only reflection would be it's a matter of enforcement, isn't it? If you've laid down a rule that says to be a cooperative, you have to use legal structure X, you know, you have to say, well, if you don't use legal structure X, this is what happens to you. It might be unlimited liability for the members. You know, you could say, well, it's not a valid structure, or it might be some kind of criminal offense. And if you're convicted of it, you get fined or whatever. But I think you do need to have something. Otherwise, there is a danger that people will use it. And I believe there have been instances in South America, for example, of the abuse of the cooperative structure to really effectively exploit people and pay less than legally required wages and so forth. So, I mean, there are always those dangers, but I think you have to make the system such that it will kind of protect cooperatives from that. And I think ours, by and large, does, because you can only use the name in certain circumstances. And there is the whole business. You can strike off a society and so on if it doesn't meet the requirements. I mean, again, how often that happens or how easy it is to achieve, I'm not sure about, but it does exist as a remedy.
Thank you. It's definitely happened, but as you say, not massively often, but it has definitely happened a few times in the last few years at least. And there's been a couple of comments in the chat that leads into the last area about, I suppose, thinking about what you'd like to see happen in the future. And a few people as well have noted the Law Commission's stated review of the Cooperative and Community Benefit Societies Act, and there's a separate review of the Friendly Societies Act, but in particular the review of the Cooperative and Community Benefit Societies Act. So perhaps thoughts for the future of co-op law and thoughts on the Law Commission exercise.
Right, thanks, certainly I'll do that. Okay. Maybe I'll start with the Law Commission. The Law Commission are at this very preliminary stage, as I understand it, although I think you should never underestimate how much that kind of stage gets solidified into effectively, you know, plans or proposals. So I did send them some answers to questions. They contacted me kindly, and so I did send them answers to their questions that they asked. And when I get round to it, I have to say, I'll put those up on my website so that people can see them. But essentially, I advocated what I've just said, which is really don't start going for a totally radical cooperative law type thing. And I have the impression that wasn't their plan anyway. Obviously, this is preliminary. And at some point, presumably now next year or early next year, the Law Commission will formally launch their proposals and consult on them, and everybody will be able to feed into the consultation, and then they'll come up with a report. So that is a process that's ongoing. I think it's really important that the co-op movement and everybody interested in co-ops does take part in that. And it's fairly easily accessible. If you go to the Law Commission website, you can find it fairly easily. I must admit, I'm a bit vaguer about the friendly societies thing because I'm not so well informed about those. Although, of course, historically, they were earlier than cooperatives, and it was out of the friendly societies that cooperatives emerged. But yeah, so the Law Commission, I think everybody should try and put their oar in, put in their thoughts at any stage they can. And of course, it's bound to be the case that the earlier people do that, the more it might influence the original consultation document. I think once they've issued the consultation document, they're not likely to roll back from the fundamental ideas, it seems. And they're not, in my view, very likely to come up with some utterly radical new ideas, such as a totally new act, which totally changes what the rules are. So I do think, you know, it's important, and it's important people contribute to it, but, you know, only a limited importance, I suppose I would say. What would I like to see to happen in the future? Okay. Broadly, I think it's appropriate to have continued ad hoc law reform. In other words, you know, I don't think in this country it's going to work to have the total revision, total replacement of the legislation. In the end, the 2014 Act was a consolidated
I think we might be losing signals slightly. We'll see if we get that back again. So, Ian, I think we've lost you slightly on signal.
It wasn't a complete rewrite.
So we'll get Ian back into the room shortly. Looks like there are problems with the internet connection. In the meantime, were there any questions or things people wanted to feed in that we can bring back when he reconnects?
Ian, can you hear me?
Yes, David.
Hello?
Yes, please go ahead. We can hear you. Oh, Ian, you've rejoined us. There's been a few technical issues there. Ian, are you back with us? Oh, we've got video again now. Hello.
Yeah, can you hear me?
Yes.
Ah, good. Sorry about that. I have no idea. It might have been this end. The Wi-Fi is a bit dodgy.
That's okay. You were talking about things you'd like to see in the future, I think.
Yes. Keep it ad hoc. Keep, as I implied before, administrative registration rather than legally defined requirements. That would be my view. as I already said, with, again, some discretion on the administrator's part. And I think the FCA have done a pretty good job on that, and the guidance is particularly helpful. Don't have the principles in legislation, okay. And the other thing, which is, I think, a problem, and this is a bit obscure perhaps, is if you can, of course, transfer the engagements of a cooperative or amalgamate a cooperative with another society and so forth. However, if you choose to go through the Insolvency Act procedure with a cooperative that is not insolvent, a cooperative that actually has assets, more assets than its debts, if you choose to do that, there is a problem. And the problem, to be precise, is section 107 of the Companies Act, or the Insolvency Act, sorry, not income, the Insolvency Act 1986, section 107, which says that on a solvent dissolution, where there would be a surplus probably, the surplus is to be distributed, quote, to the members in accordance or according to their rights and interests. Sounds fair enough, and it is fair enough for a company. Difficulty is, and to cite a great man, when the Co-op UK was subject to an attempt to privatize it by Reagan and so on, I was present in a conference with the great Jonathan Sumption, who later became a law lord and is now a retired law lord and expresses his views quite extensively. And the question was, what would happen if this privatization went ahead? And what would happen on a surplus distribution? And I argued that, well, it's a cooperative and it's got all these provisions about being a cooperative. Therefore, surely the surplus should distribute according to people's transactions with it, or equally, or to another cooperative, and not to the shareholders in proportion to their shareholding. He didn't like that. He basically said, no, it'll be the same as a company that would go according to shareholdings, because his opinion was that according to rights and interests, which is what section 107 of the Insolvency Act says, meant that and nothing else. As a result, or maybe already, cooperatives generally, particularly Cooperatives UK, make sure, cooperatives will have their own provision in their own rules, which will typically say, if there's a solvent dissolution, everything goes to another cooperative, might say what kind. In other cases, like the agriculturals, it will say, look at what transactions they had with the cooperative over, say, 5 years, and distribute surplus assets proportionately to the members according to their transactions. And it seems to me either of those are fine. It's maintaining the cooperative movement, or it's giving members assets according to their transactions, which is the cooperative principle. But the problem is that Sumption didn't take that view. Maybe he's changed his view. I don't suppose he has. And that to me is a problem, because if the thing is wound up, well, it has a surplus, it's going to be divided according to shares. Now, of course, if it's one member, one share, that probably isn't too much of a problem. It's effectively distributed equally. But it struck me that was a problem. So I would change that. I would write in that it has to be according to cooperative principles and so on, or to another cooperative. So that was my key suggestion for change. And the other thing is that that was the main point I came up with, really, when I was preparing. Other changes might include tidying it up a bit, but actually I think the 2014 Act works pretty well, and given I favour the administrative system for deciding whether or not something is a cooperative, I'm quite content with that, really. And so I wouldn't have a compulsory cooperative act, and I would continue ad hoc legal changes, no other than some big new cooperative act, which will never happen. And if it did, would take ages to change. And I'm quite happy with administrative discretion about whether something is or is not a cooperative. And of course, the ICA principles are central and should always be the key test. So I don't know if that's helpful, but so the only change really I would suggest is to the surplus distribution if it dissolves when it's solvent.
Thank you. And assuming things remain largely in that space, I suppose the next question which came through from the chat is, how would you get the option of a cooperative structure to be more widely known if you're going to a firm of accountants or solicitors or business advisors? And obviously you've worked for a few firms which are probably outliers in actually knowing that a cooperative is available. But they're very much outliers from the norm of provision of advice. So what are your thoughts on how people be offered the choice of this? And then I'll bring in some questions from the floor.
Right. Well, the only thing I can think of, and I think it's important, but it would be difficult to do, I suppose, is that you persuade or force or require university management and business schools to teach cooperative law to their students. And you ask that the accountancy professional exams should involve cooperatives, and indeed the law society and bar exams. So in other words, educational stuff for professionals. That would at least mean people knew what it was. Because there are a lot of problems and illusions about it. A lot of people think a cooperative is actually some kind of charitable stroke altruistic body, which, you know, it could be, but that's tricky. So that would be my main recommendation. It's about educating the professionals about what cooperatives are and how they work. Other than that, it's kind of disseminating the information and I suppose making them known. So maybe try to persuade accountants and lawyers to get more involved, but it's hard to see how that happens. I appreciate that because it's not very lucrative work. So I'm afraid that's probably not a very helpful suggestion, but it's the one I think would work best is in business education. So.
Thank you. And I'll bring in a few questions from the floor. David, I don't know if your question just got answered or not, but if not, go ahead.
It is, and just to thank Ian for his kind help in sharing the evidence, the preliminary evidence that he sent to the Law Commission. My understanding is this, and I'm not sure how best we can actually cope with it. My understanding is that the Law Commission review came into existence because the Treasury wanted to stall a range of amendments to the in the form of the 2014 legislation. And so what they actually did, they just gave way on one aspect, and other aspects were kicked into the long grass, and the long grass being the Law Commission review. Now, that's not usually the basis upon which the Law Commission actually does its reviews, as I understand the situation. I mean, I'll give you an example in leasehold reform. So I think there's going to be something much more than ad hoc in the way they actually respond in the consultation that we're going to be receiving shortly. And my understanding further to that, and I'll finish on this, is that the consultation probably will be running from early spring to July to fit in, if you like, with the need for the Commission to actually report to Parliament before the end of this session. Thank you.
Yeah, thanks, David. Very helpful.
Did you want to come back on anything on that or add to any of that?
Well, I mean, only to say really that the Law Commission has its own kind of duties and requirements about how it functions, because it functions under its own legislation. Don't claim enormous expertise on that, but they can't really just pick something up because a politician would like it to be dealt with to avoid amendments. I mean, I think that may be why it gets referred to the Law Commission, but once it's there, it will be subject to the standard Law Commission process, is what I'm saying, really. And they do have very clear, quite strong processes. But yeah, I think the preliminary consultation was probably quite important, because obviously if they'd found that everyone said, you know, we want to do something radically different, then maybe they would write the consultation paper differently. But those are my only thoughts on that, really.
Thank you. Got time for a couple of questions to bring from the floor. Ian Hewitt. So we're not getting the sound from you there, Ian. We can come back to you in a moment if you're having issues with your sound.
Is that better?
Ah, yes, that's better.
Ah, good. Sorry about that. Right, this is a fairly lowbrow question, and it relates to this idea of not defining things too carefully. I was involved in establishing a community co-op about 25 years ago that has recently run into difficulty. Now, it's an ICOM community co-op, but the Constitution nowhere says that it's a co-op. There's a little tag that says contact ICOM, if in doubt, contact ICOM. But the people that have now got control of this co-op don't even keep a register of members. They're not sure what members are. They elected themselves into positions of have an AGM and always elect themselves. And they really didn't like the idea that I was causing trouble by saying that members have rights and really should be involved in the election. And I'm just wondering how you kind of turn that situation around, because there isn't much expertise, and the people running it and the politicians involved aren't really interested. They think it's just problematic. You know, this idea of democracy and members goes against their ideas of political control or control of the organisation. And yeah, so and I think that the root of that is that the Constitution doesn't say it's a co-op.
Okay, shall I come back on that? Yeah, I mean, I'm not sure how significant the Constitution not saying it's a co-op is, but obviously it would be helpful if it did. My feeling is failure to keep a register of members is obviously a breach of the legislation. But again, it's a question of how you enforce that, or indeed how an enforcer, for example, the FCA, is aware that it's not being done. And the underlying problem, it's worth mentioning this, it's always been difficult with companies before the 2014 Act, the 2006 Act, to go to the courts about these problems, because, you know, it's very expensive, it's troublesome, there's a whole lot of rules around stuff like unfair prejudice and what it means and all the rest of it. So it's hard with companies. With co-ops, it's even harder, because there's no easy way or obvious way of getting to the courts. That has improved that for companies under the more recent legislation. But with co-ops, there's nothing. I mean, there's nothing that says if members are unfairly prejudiced, which is what the Companies Act says, they can make an application to a court. I agree, courts are expensive, slow, etc., but it is a remedy, and you can at least threaten people with it. Whereas there isn't the unfair prejudice thing. And I don't want to go on about this too much, but what used to be called the rule in Foss and Harbour, which is that a member can bring an action in the name of the company or society in the court against people who have ripped it off, basically. That is, as you can imagine, expensive, difficult. It involves two processes. And for co-ops, it's still a common law thing. whereas for companies, that's been put into the Companies Act. So if you can't go to the courts, and if the problem is such that it's hard to get the regulator, which is of course the FCA, to act on it because of the particular problems, then the answer is it's very hard to do anything. I mean, and what you describe, Ian, is a kind of situation which seems to me falls into those categories because it's difficult and expensive. So a member who's dissatisfied could try bringing a just and equitable winding up petition, which you can do in either a co-op or a company. But, you know, it costs a fortune, slow, difficult. And the end result is that the thing is dissolved and wound up, and whatever's there might be distributed. But if there's nothing there, or if the distribution will not even cover the costs, not a very realistic remedy.
Thank you. Was there any, I've got time for one final question. Elizabeth.
Hi, thank you so much for this discussion. So a short question, we kind of touched upon it, and it relates to your last comments. So I'm coming from academia, from accounting, and I actually saw many similarities from my discipline in the sense of trying to change regulation, because I'm exploring accountability practices and how can you develop accounting specific to cooperatives. So I was a bit interested in your views or experience about the role of academics and the impact they can make to economy and society. Because, you know, from my research, I, became aware that we need to kind of transcend disciplinary boundaries and, stop having this dualistic approach of, either an activist or an academic. And we really need to take part and build an activist academia and try to transform the world eventually. So if you have any thoughts or experience about the most effective ways of regulatory change, the resources, the networks, what from your experience you have done to kind of promote change towards this direction, and always considering the UK context and the way things work.
That's an excellent question to wrap up on. And if Ian, if I can invite you to answer that. And then
it is. It's a very good question. Obviously the role of academics might vary from one place to another, but the answer, in my view, and this is a bit cynical perhaps, is if you want to make things change and make people change things, you have to find out what they want and what they're frightened of, and use those as your lever to get the change you want. So I'm trying to think of an example. So I mean, the problem, say, for cooperatives, their worry might be being demutualized, being, privatized. So you start working on, well, how could that happen? And if it did happen, what would the consequences be? And how could you realistically prevent it? So I'm not sure this is much of an answer, but I think you have to do it that way, because otherwise you're not going to recruit people to support you in what you're trying to do. So in a sense, what I'm saying is you use people's own self-interest as a means of trying to get the policy change or the other change that you're trying to achieve. I don't know if that helps, but it's a bit okay. Thank
you for that. That's been fascinating, and I know there's been a lot of interest in the chat and other comments. It's been really excellent to hear. So if we can show our appreciation in the usual Zoom way for those that can find emojis. So thank you for that. We're going to make the recording available afterwards, because I know there are a lot of people that couldn't that couldn't attend. We'll put that on the UK Society of Co-operatives website. I'll put the link to both Ian's website and our website in the chat. There's lots of resources on Ian's website as well. But with that, yeah, just to say thank you, and that's been hugely useful. We hope you continue doing bits of writing and other involvement as you wish for for a long time to come, probably much longer than you want to, but we hope, selfishly, we hope you continue for as much time as you're willing to do so. But that's been really useful, and I know people have certainly enjoyed this. So thank you for that, and thank you, everybody.
Thank you, Ian. That's very kind, and it's been great to do it. I've enjoyed it, and thank you everyone for attending and staying there till the end. So.